back from the break. I'd like to introduce our distinguished panel who are going to give their considerations in relation to both legal translation and the QUALETRA project as well. If I can just introduce, and I must make sure I get everyone's titles absolutely correct. On the right we have our judge Richard Monkhouse, who is Deputy Chairman of the Magistrates Association. Beside Richard is Louise Hodges, who is Vice Chair of the European Criminal Bar Association. Then we have Christiana Driesen, who is a trainer from Magdeburg University. Oh, sorry. And finally, and I'm hoping I'm going to pronounce it vaguely correctly, we have our legal translator, Zofia Rubinska, who is Vice President of TEPIS, which I must tell you is the Polish Society of Sworn and Specialised Translators. So if I can hand you first of all over to Richard Monkhouse, who is going to get us going.
Thank you and good afternoon. Terminology. It says on the paper I'm a judge. I'm actually a judge one day a fortnight. The rest of the time I'm a normal human being. I'm a magistrate. We sit in magistrates' courts. We deal with all summary justice in the UK. In England and Wales. We deal with 95% of all crime. It goes as far as our sentencing power limits, which is 6 months in custody, although we are talking to the government about trying to increase it to 12 months so we can make better use of courts and not clog up Crown courts quite so much. We operate an adversarial system, which is really why interpreting is absolutely vital. And if I can give you a particular example, about 4 weeks ago I sat in not a criminal trial but a UK border agency trial for someone who'd had some money withdrawn from them or threatened to withdrawn from them. She was an Asian woman who was here to support her daughter studying at one of the Manchester universities. She'd been earning money, they said unlawfully, she said not. They persuaded her that in court, or before court, that actually the money needed to go back to the UK border agency. We sat as a bench, I was chairing, and during the proceedings it became perfectly obvious to me and to my two colleagues that this woman was merely trying to be compliant. She didn't actually understand the process, what was going on. We understood, we actually asked the question whether an interpreter had been offered to her. The answer we got was yes, but she declined it. So I asked the question of her, are you completely satisfied that you're fully aware of the process? We're not trying to determine at the moment whether the UK border agency are right or whether you are right, but we want to know that you are content, that you understand what is going on here. And she said, well, yes, and that was enough for us. We called a halt to the proceedings and said, I'm sorry, this can't go on. We're going to adjourn the case amid screams from our legal advisor in front of us. Well, nearly screams. She was, oh, I can't do this because we have case listings to worry us. And I said, I'm sorry, the interests of justice are not being served by this woman in this court not being properly represented. At which point she said, I can bring my daughter. And we said, no, we want a properly qualified interpreter. We'll set it down for another date. At that date, this event can be fully examined. You will be fully cognizant of what is going on, which is the issue, rather than whether you are right or they are right. That's why we need interpreters. We increasingly operate a problem-solving courts in this country, where for a welcome change we don't regard the defendant as some spare part sitting to one side and listen purely to their lawyers. We talk to the defendants, in not every court, but certainly the one I sit in. We talk to the defendants once they have admitted their guilt to try to understand what it is they are has led to their criminal behaviour. Bear in mind that probably 70% of the cases we hear, we do not require probation service, we do not require the youth offending service to give us a report, because the offence is not that serious. We will be considering a fine, we will be considering maybe restorative justice, we will be considering maybe a conditional discharge, something of that level. And if you are not bringing the other agencies into the act, then this person cannot get any rehabilitation. And that's part of what we need to do. 5 purposes of sentence, one of which is rehabilitation, one of which is punishment. There are others. So if we are dealing with somebody who is whose first language is not English, who, and I'll give you another example, has on his way through Tesco sampled about 7 different ice creams from the different bags, not speaking very much English, we want to understand why he's done that. We want to understand whether this is common practice where he's come from, or not. Or it may well be, but we want to understand that, because that actually plays a part in how we sentence. If we can do that with somebody whose first language is English, and that's difficult enough, then that gives us that advantage. If the person standing in front of us doesn't have that language, we're certainly not linguists. I'm embarrassed to be here. I speak one language, and that's Manchester. But it's a difficult situation, and we have if we are going to abide by our oath to treat people exactly the same, whoever they are, wherever they've come from, then we need that facility. To help us along that route, we've gone into I've been doing some training with a company up in Manchester called Interprite. I've been doing it now for 9 years. And it embarrasses me to think that it took me 8 of those years to realise that while I was helping in their training of their NPSI students, they were not actually coming into our court and talking to our magistrates and our sentences about interpreting. So they came in, and rather than read a PowerPoint and tell us exactly what we needed to do, they laid on some interpreting exercises. And it was just brilliant. One bespectacled, grey-haired lady, who's still a magistrate, said to me afterwards, "That's the best training I have ever had since I've been a magistrate." Because it made us understand that it's not just about the translation of language, it's about the translation of culture, it's about all of those things that actually mean that if we're talking to people whose first language is English, we can understand when a defence lawyer is badgering the witness, or a prosecution lawyer is badgering the witness. We don't fully understand that if the language being spoken and if the translation going on is not in English. So that's why it's important that we have interpreters, but it's important that we have that dual relationship with interpreters. We know that this cooperative training has been happening in London. It's now happening in the north of England. We've tried to get it started in Wales, and that's ongoing. But this is almost saying to you, as part of the criminal justice system, certainly in England and Wales, you are part of us, and we are part of you, and together we administer justice. It's not that we administer justice as judges and as sentencers, it's the whole system. And one of the difficulties in this country is that when the public say that they have got a lack of confidence in the criminal justice system, it's actually about understanding what those processes are. The more we can help to educate people within the criminal justice system as well as outside it, the more we are actually doing our job. And we in the Magistrates Association have this as one of our roles, engaging in the public, engaging in the rest of the criminal justice system about what it is we do and how it is we do it. I'll finish off just by referring to the ALS Capita contract. I wasn't involved in that. But I wasn't. No, you want to change the profit motive, change the government. But I didn't say that. I was involved in the very first meeting that started to look at this. It was up in Staffordshire, because the ACPO police officer lead was the Chief Constable of Staffordshire. And I went on to the first meeting, and when they were talking about minimising, downgrading the level of interpreting in courts, I started to make the obvious comment. Unfortunately, I was the only member of the judiciary there, which is one of the problems, that when we don't have people represented, I was obviously a bit too verbose because I didn't get invited back. So we didn't have a part, nor should we. We don't provide the interpreters, but we are the recipients of interpreters in court. In family court particularly, it's not just interpreting, but it's also translation, because there's many documentation, many documents to read before. I don't sit in family court. I think it would depress me too much. But that's why it's very important in a multilingual society, which we are, and I'm pleased that we are, even though I'm embarrassed not to be one of those members. We need interpreters, we need that link between interpreters. That's as much as I want to say, but if there's any questions afterwards, happy to answer them.
Good afternoon, everyone. Thank you for inviting me here to speak to you today, and thank you for all staying so late. I don't think I've ever been to a conference when everyone's been so diligent and has remained in their seats for so long. I'm not doing a presentation, I'm just going to do a very brief sort of introduction, and then when we have the questions and answers, you know whether to direct anything to me or not. As the previous speaker, I've been listed as the Vice Chair of the European Criminal Bar Association. That's not my day job or my paid job, that is my sort of hobby, I suppose, for want of a better word. I'm actually a defence lawyer, and I practice in London. I practice mainly dealing with white-collar crime, but my firm does the whole gamut of criminal offences. And the European Criminal Bar Association is an association of independent defence lawyers. Well, in fact, predominantly defence lawyers, although we do have members of the judiciary and prosecution lawyers who are also members of the association. And our independence is that we volunteer to become members of this organisation. As part of the QUALETRA project, we've also been working with the CCBE, who are the sort of the pan bar and law societies of Europe organisation, and we work quite closely with a lot of projects with them, and particularly with their criminal law committee. So just, it will be no surprise to you that as a criminal defence lawyer, I think quality of translation is extremely important, and I do mean quality of translation as distinct from interpretation as well, because there's many court documents that are produced that really set out the offence and what the case is that the defendant is facing. And if there are mistakes in the translation of those documents, then essentially you're working on a false premise from the start, both as the advisor and also as the individual. And at different stages throughout the process, there are procedural documents that are provided. They're different in different jurisdictions, but that there is generally a theme of procedural documents that are provided. The directive has obviously acknowledged that there are some essential documents that just by the nature of those documents need to be translated, and then there's another body of documents that they refer to that may be essential, possibly on a case-by-case basis, which could be identified either by the central authority or by defence counsel on application to the central authority. It's not in the automatic gift of the defendant or their lawyer to determine whether a document is essential or not. Just picking up on some themes from today, when looking at quality of translation, I don't personally think that getting the gist right is the level that we should be looking at, and I'm sure that the rest of you in this room don't agree with that as well. I think from a defence lawyer's point of view, quality, accuracy and timeliness are the essential elements. There was also raised today the question of confidentiality, but I think that generally is more to do with interpreters rather than necessarily translation, apart from if there's translation of the defence documents. Sorry, lots of people are disagreeing with me, so we can discuss that later. Great, a little bit of controversy. Excellent, I like it. And also impartiality, I think that is an important element as well. But we can't be foolish and not recognise that costs is also an important issue in terms of translation, and that in fact that's generally going to be a determining factor in many cases. Just very quickly in relation to QUALETRA, I'm a bit of a fraud standing here because I haven't really been particularly involved in the project. And in fact, the CCB have probably been much more active and participating on a much higher level than I personally have anyway. But we're in the process of collecting essential documents that will be used as this source material for the project going forward. That is in process, and our meeting today, we're getting a strong message that that process needs to be as quick as possible. I've taken that message on board, thank you very much. Finally, I just think in terms of the essential documents being a broader scope than what's defined in the directive. Thank you, James, for your list, which we shall adopt fully and extend hopefully, but that's a very useful list that you provided there. And certainly in some jurisdictions, and certainly here, there are lots of obligations on the defendant to provide information, and of course making sure that that is translated accurately is of extreme importance to those that defend those individuals. That's all I'm going to say now, and I look forward to a discussion later on. Thank you.
So it seems I am the next speaker, Zofia Rybinska. I am the representative of the Polish Society of Sworn and Specialized Translators. Let me only take water because I may need it. Okay, yes, yes. Of course I presented, I have prepared the presentation, and for time concerns I will of course not present the whole of it. And just to let you ask some questions. But let me stress again that in Poland the profession I am a representative of, sworn translator, covers both translators and interpreters. And this profession is governed by the law, namely the Act on the Profession of Sworn Translators, which imposes great responsibility. Why? Because we are persons of public trust. This is the first issue. Then we are responsible for our acts and all translations and interpreting. We bear the statutory responsibility because very often we sign and affix the seal under our translation. So the responsibility is of course very, very, very big. And we translate lots of documents. We translate lots of documents, and not only the ones which are given in the enumerated in the directive. And for us, quality is very, very important. Quality depends very often, of course, on the knowledge of innumerable domains. And the vast array of such domains is indirectly determined in the Polish law. So ideally, our translation should be of deliverable or publishable quality within the meaning of expectancy norms. Of course, I will not go now into detail about the quality or the translation product, but what is what is important is that the product of our translation must be free from errors, because it entails otherwise what? Serious legal and financial problems. Not to mention that sometimes people's life may be at stake. This may adversely influence their lives. So, something happened. We cannot expect that we will be given only very good text, well written, composed clearly. Very often we encountered muddled narratives, ungrammatical materials, and we must be acquainted with all the rules for creating deliverable form of official translation. We of course must be familiar with necessary strategies and act in line with professional ethics and good practice developed by the profession in Poland. And you are already familiar with the Act on the Profession of Small Translator. It doesn't say anything about the quality, only provides two conditions: to obey the rules of professional ethics and the duty of continuing professional development. And of course this act shows respect to us, to professionals, and empowered, for example, our association to establish more detailed rules of ethics and good practice. And our Swan Translators Code was drafted in cooperation with the representatives of the Ministry of Justice in 2005, and it has been in use since 2005, and for us is an authoritative source of knowledge, determines the quality of official translation, creates a point of reference for us, gives us what is wrong, tells us what is wrong, what is right, so just to avoid very many mistakes or conflicts, even with the administration, judicial administration. It provides also for us rules of good practice, which are very, very helpful. I have no time, but to go into detail, but the principles of professional ethics tell us that we are obliged to carry out translation with special care, maintaining fidelity to the source text according to the rules of specialist translation and formal and legal principles of judicial and legal translation. And of course, I have already mentioned about the personal responsibility for our duties and tasks. When we have two sections which enumerate the rules of professional practice, and the one referring to translation, of course, gives us detailed instruction as to ways of translating, omitting, adding different elements to an original text, and so on and so forth. But taking into consideration the personal responsibility before the professional accountability board, of course, such rules must be followed. I was thinking about cooperation with legal professionals. What can be done? And I think that much can be done, because we very often are believed that we are experts in every field. Of course, we have, as professionals, required skills and know which strategies to apply to a given text. But very often we are free from doubts. We are not free from doubts. We may lack necessary legal expertise. And I think that there is room for legal professionals, and they should spare their time and help us in such a way that they are ready to consult when the need is. As we all know, that the language of the law has a lot of snakes in the grass for non-lawyers, and very often translators are not lawyers themselves. Of course, many improvements could be done with respect to the language of documents we translate. Sometimes I think that a plain language campaign should be is necessary as far as the texts are concerned. We have various narrative parts which are very often ungrammatical or muddled texts, so then we really have problems. And I think that very often texts are written not in a plain language. Let me tell you, give you an example. For example, we have a letter of rights, a very lengthy text, 32 paragraphs rewritten absolutely in extenso from the Criminal Procedure Code. So when it is interpreted, of course it may be explained to the victim, but when it is translated, we must render the style of the source text. I think that desirable improvements could also be introduced to working arrangements. For example, in Poland, decisions to appoint sworn translator have no contact details, no contact data, no telephone, and very often we would appreciate to have such contacts. Also, very often deadlines, also the date for delivery of translation is not prior agreed, and it doesn't cost much. It is just, it takes a phone or an email. It is really very easy to contact a translator in order to avoid an overlap. In some cases, also information on the quality could be advisable, because not all texts require very good certified translation. In matters of urgency, I believe that sometimes the quality may be a little bit less. Of course, the meaning, the translation should be, the accuracy of translation should be conveyed. And the fees, we have already said about them, so I will not go to this point, because in Poland we have very deplorable fees. Concluding, I would say that quality doesn't come for free, nor without hard work and adequate investment. And I think that it is really very necessary to continue professional development in order to perform all the roles we are entrusted with. So, sworn translators, experts in cultural diversity, authenticators to the facts, linguistics experts. So we must constantly refresh and develop our knowledge and skills. And for example, in Poland, continuing professional development is left absolutely to sworn translators themselves. And I think that it will be welcome that the Minister of Justice understood the importance of continuing professional development and could assist translators and association in offering training. Quality must be well paid. Conscientious sworn translators constantly subject themselves to critical self-assessment in order to find out whether they live up to requirements of their profession. So I believe that there is a great role to play by our minister. He shouldn't only keep the register of sworn translators, but should also assist those registered already in the register to update their skills, acquire more expertise, and of course knowledge in order to increase confidence and reliability. In Poland, CPD is mentioned in the Sworn Translators Act, but the Minister of Justice doesn't attend to this provision and doesn't feel responsible for this implementation. On the contrary, the Minister of Justice is considering lowering the quality of translating and interpreting by including the profession of sworn translator on the list of professions to which he intends to deregulate access. So, hopefully, the measures taken with regard to the transposition of the directive will bring about the necessary amendments to the existing law. Things are very quickly changing, and we must ensure that they change simply in the right direction. Thank you.
afternoon again. I hope I'm not going to bore you, but I will, because I've already spoken, that's why. But I will first of all take the advantage of being able to contribute to this panel to give my little comment to some of the points which have been mentioned. First of all, of being in Britain, in London, I'm nevertheless very much aware of your problems, and I've always been wondering about these problems of procurement, which come again and again in Britain, where it could be maybe organized by a law. For instance, in Germany there is a law saying how much a translation has to cost per line, and it is for the time being from 150 to 4 euros per line. And one of the spin-off of our new directive will be that the government, the German government, the ministry tries to lower the price of translation, because there will be more translation needed. So on one hand, the price is quite good. I cannot manage per word, but I think it's quite decent. That's the reason why in some of the Bundesländer the interpreters, the Association of Interpreters and Translators, were totally against splitting the professions, because you earn more money as a legal translator working not only with court but also for very good law firm, and it's very good to be a translator and also an interpreter, where you have, for instance, to get up in the middle of the night to interpret. So that the reason why they wanted to keep the two professions together, that if you have to spend the night at the police station, for instance, nevertheless the next day you can be able to earn a big amount of money translating. That's why it was the reason behind it. But the law, there exists a law, and I can tell you this is for translation, but for interpreting exactly the same. The fee per hour is 55 euro, and everybody knows it. It's per law, and you don't need to have a procurement. You know how much it will cost in the budget of the state. But this is a small remark. There is one thing which I wanted to mention. It's a little remark, but what I think for this roundtable, the roundtable is for between stakeholders, and that's why I wanted to mention to remind you of this Article 6 of the directive, which is training. And at the beginning, I thought training, when I first read the heading of this article, I thought training, well, it's for interpreters again. But this is an aspect which is very important, and it is training of the legal profession. And what do we need to train? I participate in a project in Paris, organized by EASIT, the other interpreting school, where we train with lawyers together, lawyers and interpreters, translators, and terminologists. And I've seen Sandrine, Sandrine Peraldi, who is also part of the project. And there we train young lawyers from the Bar School of Versailles how to work with translators and interpreters. And what do they learn? They learn, first of all, how to communicate with translators and interpreters. What does a translator need to do a proper job? How much information? This is one thing. He has to respect confidentiality, so you can trust him and give him the full information so that he can deliver proper work. Then what you need as a lawyer is to be able to evaluate the quality. First of all, to understand what it means to translate from one language to another. What do we hear, interpreters and translators, every day, every hour? You don't need to know, you only need to translate if you ask for information, for a piece of information. This is what you are told. So you have, first of all, during this training for the legal profession, to tell that it's not enough to be informed about, to have to translate, that for translation you need more information, more background knowledge, and that you can trust this professional who will work properly with it. And I think what is very, very regrettable is that national court system have hardly any contact with European or international law system where things are properly organized. As a translator with, and James could confirm it, with an international court or European court, you get all the information. So all the dossier, you get everything so that you can do a proper job. If you don't need to have this information to translate, but what is this fidelity of translation. You have to translate, and also in legal text, you will find that the interpreter has to translate word by word. So I could, and I'm sure many of you in this room could give examples how ridiculous it can be to translate word by word. To prove my point, very often I take, for instance, a birth certificate, put it into the computer and let it translate by Google Fish. And then you have the result, and then you can show that, you can prove that translation of a legal text word by word doesn't mean anything. And one aspect, it's also a comment to